Welcome to our webinar. Hope you are all well. I'm Leslie Hendricks, the Project Manager for the South African Furniture Initiative, and I will be the tech support for today's session. This webinar is hosted by the South African Furniture Initiative, SAFI, in association with the Cape Furniture Manufacturers Association and the Garden Route Employers Association. First, we have our program, which will just be opening and house rules. Welcome by our SAFI MD Bernadette Isaacs, our presentations followed by a question and answer session. Let's start off with the house rules. Can everybody please switch off all video and audio? Please note that the presentations will first take place followed by the Q&A session. So if you have any questions for the Q&A session, please leave them in the comment section addressed to the host anytime during the webinar, and then the presenter will respond to it during the Q&A session. Questions that are not answered during the webinar due to time limits will be addressed offline and included in the post-webinar feedback communication. Thank you again for joining us today. Here is our Managing Director, Bernadette Isaacs, that will facilitate today's session.
Thank you, Nasli. Once again, welcome to SAFI's first webinar. As part of our support to the furniture industry, we aim to bring the most relevant urgent matters to these types of platforms. Our core aim is to give the furniture industry a voice and to enable information sharing to assist our industry to sustain and grow. As you all may have known, we are a joint initiative of industry, labour and government with a common interest of promoting employment growth and transformation of the furniture manufacturing industry. Today's session is one of a very important topic, which is the impact of COVID-19 from the labour relations perspective. I am very pleased to have an industry and subject matter expert who's presenting the information today. Let me introduce you to our presenter, Mr. Jerome Mausling. Jerome Mausling completed his full commissioner training in 1996 under the auspices of the CFMA. Started an employees association in 2000, which is still operating today. Joined the Cape Furniture Manufacturers Association in 2003 as the secretary of the CFMA, and is part of the wage negotiations team for the furniture manufacturers at the Furniture Bargaining Council in the Western Cape. For 10 years, he was also the employer's representative in labour matters for the Fuel Retailers Association, and is a director of the Labour Compass, a labour consulting firm. Mr. Mausling has an LLB degree from UNISA and a certificate in arbitration from the Association of Arbitrators. So without further ado, I would like to hand over to Mr. Jerome Mausling. Thank you, Jerome.
Thank you, Bernadette. Thank you, Nasli. Thank you for the opportunity to address people of the industry. I hope that they find this webinar useful and helpful. So as an industry, we are facing really challenging times, not only because of the impact of COVID on our industry, but even from before the advent and the impact of COVID, we were an industry in distress. And from 2019 onwards, the beginning of 2019, we started seeing a number of retrenchments in the industry and a downsizing of about 8% in the furniture industry in the Western Cape. By 8%, I mean retrenchment of about 8% of the industry. Now, with the impact of COVID, we are faced with even greater challenges. Many companies have been speaking to me over the course of the lockdown about the state of their business, what they face when they open, and the long road to recovery. There's deep concern about whether the industry will survive. Many manufacturers are considering closing their operations because times were tough even before the advent of COVID. So in my discussions with manufacturers, I've attempted to apply the law to the situation and also to apply some practical advice. In terms of the Furniture Industry Bargaining Council collective agreement, in a situation where there is slackness of trade, an employer is allowed to issue a notice of short time to its employees. The notice of short time allows an employer to reduce an employee's ordinary working hours on a no work, no pay basis. Short time is a short-term solution for a situation where there is slackness of trade or perhaps shortage of materials or due to difficulties in the employer's operational requirements at the time. My advice to employers is to apply short time first before you consider retrenchment. The reason for this is you may only be faced with a short-term challenge and business may pick up very shortly for you. You would then have gone through a retrenchment process. That process would have cost you money. You may need to re-employ people again. So my advice is, if you view, and you know your business best, if you view your situation as a short-term facing a short-term challenge, then my advice would be to issue notices of short time rather than to engage in consultation about retrenchment. In order to issue short time, you simply need to give notice the day before. This must be written notice and issued to employees that will be affected. Can we have the next slide up? Thank you. In the situation where you place employees on short time without notice, there will be a requirement on you to pay them no less than 4 hours for the day. In other words, if somebody reports for work and you send them home, they need to be paid for at least 4 hours. If you give them notice the day before, then that would be sufficient and the principle of no work, no pay applies. The collective agreement refers to 1 hour's notice. My advice always is to issue notice at least the day before. In the furniture industry collective agreement for the Western Cape, if you work short time for 60 consecutive days in a year, you need to then engage employees in consultation or make an offer of retrenchment to employees. The likelihood of working 60 consecutive short days is not that great, but it is a consideration to keep in mind. If short time is not an option for you and you are faced with an indefinite period of uncertainty, or you are certain that you will need to retrench because your business has been radically affected and is unlikely to improve in the medium term, then one of the considerations that you would have as an employer is to retrench people in order to save money. Employers need to ensure that their business is aligned to their demand and you want to run a business profitably. One of the grounds on which you can terminate an employee's services in South African law is on operational requirements. In the Code of Good Practice regarding retrenchments in the Labour Relations Act, guidelines are set out for employers to follow when contemplating retrenchments. It's important to note that retrenchment is no fault of the employee. Most often it's no fault of the employer, but retrenchments in general are considered no fault dismissals, usually brought about by economic changes, structural changes, and other factors outside of the employer's control. What the Act says is when an employer contemplates retrenchment, the employer is required to consult with his employees as soon as the contemplation is made. The main purpose of consultation is to engage the employees, and if those employees are members of trade unions, to engage those trade unions in a process that you enter jointly for the purposes of trying to avoid dismissal, trying to minimize the impact of dismissals, to discuss severance pay, and also to discuss the selection criteria, but who will be selected for possible retrenchment. So initially, when an employer contemplates retrenchment, a notice must be drafted. A notice must be drafted in terms of Section 1892 of the Labour Relations Act. That notice must be issued to all employees that may be affected by the proposed retrenchments, as well as unions, if there are unions representing those employees that may be affected. That notice must contain certain minimum information. For example, the rationale or the proposed reasons for the retrenchment, the alternatives that an employer has considered other than retrenchment and why they've rejected those alternatives, the selection criteria, who they will select to be retrenched. The selection criteria, it's important to note, must be fair and must be objective, or it must be agreed upon between the parties to the consultation process. Generally, you would not use an employee's performance or attendance or sick leave record or disciplinary record to select. You would use fair and objective criteria such as length of service, retention of skill, perhaps cost to company. Those are factors that an employer would apply, which are fair and objective when selecting who to let go and who to keep. These are the issues that are consulted about during the consultation process with the employees and with the trade unions, if there are trade unions applicable and relevant to the consultation process. So if I could summarize it up this way, a notice is issued containing that information, along with information such as whether the company is retrenched in the last 12 months, how many employees it has, possibility of future reemployment, means to assist employees during the consultation, during the retrenchment process, and so on. A notice is issued and meetings are set with the trade unions and the employees that are likely to be affected. Generally, it'll work in this way. And the employer will review its current structure, try and align its current structure with the economic environment it finds itself in. By doing so, it will most likely come up with a reduced workforce that meets its demands economically, and then set the two side by side. It will then determine that X number of positions may be affected in different departments. Once it's determined that, an employer will know how many people are likely to be affected by the proposed retrenchments without at this stage knowing who those people are. We merely have identified the positions in various departments, and then it would issue its notice. It will also determine and suggest to the other consulting party what the selection criteria is that it would propose to determine who should stay and who should go. So on a practical level, an employer might have 100 people that needs to reduce by 20, perhaps 10 general workers and a number of people in other departments. The company may employ 20 general workers. So it would state in the notice that the general workers, 10 positions may be affected. The selection criteria might be last in, first out with retention of skill, or perhaps also giving consideration to employment equity targets and so on. An employer would then share that notice with its employees, share it with the trade union, and then they would start a process of consultation to determine between the parties whether the selection criteria is acceptable, whether it is fair, whether it is objective. Look at ways to possibly mitigate the adverse effects of retrenchment, reduce the number of people that might be affected, change the timing of when the dismissals are likely to take place. And at that stage, the trade unions would normally have access to the employer's payroll information, so it could determine whether the selection criteria is being applied fairly, and then use the selection criteria to apply the selection criteria to the various departments where an employer may need to downsize. For example, you have 20 general workers. The trade union would have access to all the names of the general workers and their starting dates and their skill levels and salaries, and then be able to see from there that the employer is applying selection criteria fairly and that they're not cherry-picking individuals that they'd like to get rid of. During this process, it's quite important, and I always stress this when I engage employees who are consulting on their own and also with trade unions, that they are encouraged to participate in the process actively, not to sit merely and observe or sit and absorb, but to actively participate, to question the employer's rationale so that we can reach agreement at the end of the process that the rationale is legitimate. To look at the selection criteria, to analyze it, to confirm that it is the best possible solution to the situation that the employer is facing, with an attempt to reach consensus on the selection criteria. A big thing that's always perhaps contentious during the consultation process is the severance pay that's payable. Now, the collective agreement provides for, excuse me, certain minimum severance package that must be payable. In the furniture industry in the Western Cape, it is 1 week per completed year of service, plus an additional 1 week pay. And then if you have long service, 5 years, 10 years, 15 years, there's an additional once-off 1 week for each of those. So that would be the absolute minimum that an employer could pay as a severance package. But the Act does allow parties to consult about that, with the possibility of increasing that. And in some circumstances, employers are able to increase the severance pay to perhaps 2 weeks 2 weeks per completed year in some cases, or an additional amount that's consulted on and agreed during the consultation process. Once the consultation process has been concluded, one would hope that you've achieved consensus on when the dismissals will take place, the selection criteria, the severance pay payable, and the fact that there are no alternatives to retrenchment or reasonable alternatives to retrenchment. Then the consultation process would have been concluded, and an employer can issue notice to terminate services on the grounds of operational reasons, in other words, retrenchment. In a case where the employer and the other consulting party cannot reach consensus on these things, an employer has the right, the final say, to conclude the consultation process and terminate the services of employees on grounds of operational reasons. Whether that termination is fair or unfair is to be determined by the CCMA or a bargaining council if there's a challenge to the fairness of the dismissal, the fairness of the process. There are certain circumstances where you would need to follow a slightly different process. Where an employer employs more than 50 people and wishes to retrench more than 10 people, there may need to be a facilitator appointed to facilitate the consultation process. Any party to such a consultation may request the CCMA to appoint a facilitator. Excuse me. The CCMA would appoint a facilitator, a date would be set for the first meeting, and normally under a facilitation process, 4 meetings will be set, and no notice may be given to terminate the services before the expiry of 60 days from the date that the employer first issues the notice to consult to the trade union and to the employees. Not necessary and compulsory to follow that process, but it's advisable to do so. The consultation and the items over which you need to consult during a Section 189A, which is the large-scale retrenchment that I've just referred to, the content of that consultation process is exactly the same as for a small-scale retrenchment. One of the things that is also consulted about during the consultation process is the possibility of future re-employment. In the furniture industry collective agreement for the Western Cape, an employer must give an employee that is retrenched first option to return for a period of 12 months. That's a minimum requirement. That does not mean it's the same for other industries, but certainly for the Western Cape, there's a period of 12 months during which you must give retrenched employees first right of refusal or first option to return. Further to that, there's also a clause in the furniture industry collective agreement for the Western Cape that you must take them back on no less favorable terms than which they were retrenched. How fair that is going forward, I'm not too sure. My personal opinion is that if you are able to re-employ people, should be able to re-employ them at newly negotiated terms if it's suitable to both parties, but we do have a collective agreement that governs that. Is there a move on to the next page of the slide? Okay, I think we've covered everything. I hope I've made it clear in terms of the code of good practice and what the process is. When it hits an employer personally, it's quite difficult to put into practice what you read in the code of good practice. In other words, to actually consult, to issue the notice, what to put in the notice. And if you're a member of the Cape Furniture Manufacturers Association, I always advise contact us so that we can help you draft a proper notice, so that we can ensure that procedurally we follow the correct procedures. And we will also assist you during the consultation process to ensure that the consultation process is conducted fairly. The other thing that I forgot to mention is that the consultation must be meaningful. It must be a legitimate attempt by the parties to attempt to reach consensus on the things which were mentioned earlier. It shouldn't be window dressing where an employer just goes through the process as predetermined who will be dismissed, when they're going, because that would be an unfair dismissal. So rather make use of our services. If you do need to engage your employees in a retrenchment process, we can help ensure that you follow the process correctly in terms of law, and also that we engage meaningfully with the other parties. That's all I have to say. If there are questions, I'll gladly field any questions.
Thank you very much, Jerome, for that informative presentation. We at the part of our session where we would now using the chat facility in the webinar, where we will now leave it to our participants if they want to post any questions to Jerome, to please do so now in the chat section in the webinar.
Firstly, I need to make a correction to the 60-day thing. It's 12 weeks. The collective agreement refers to 12 pay weeks, which is 60 working days. But the actual wording of the collective agreement in the Western Cape is 12 consecutive pay weeks. So if you work short time for 12 consecutive pay weeks, then the collective agreement says you must give an employee the option to discuss retrenchment. I'll quickly read that clause to you. I have it here. Give me a second. It says, despite the provisions of this clause, an employee that has been placed on short time for any period during any one pay week for a continuous period of 12 consecutive pay weeks shall be offered a retrenchment option by the employer. So you have to offer the employee the possibility or the chance to be retrenched. That's after 12 consecutive weeks of short time. I've had a look at the Garden Route, the Southwestern District's collective agreement that Mornay sent me. There's no such provision in their collective agreement. So you'll see in the media reports of companies slashing employee salaries and reducing it by 15% and 20% and 30%. There's nothing in law that allows an employer to unilaterally cut an employee's salary. That can only be done through a process of consultation. So as an alternative to retrenchment, an employer can engage employees in a consultation to explore alternatives to retrenchment, such as a reduction in the salary, working shorter hours. But it cannot be done unilaterally. Companies that do it unilaterally open themselves up to an unfair labor practice or unilateral change to conditions of employment dispute, and even in severe circumstances, possible claims for constructive dismissal. So there must be consultation, and there needs to be agreement between the parties to reduce the salary or the wage of any employee. Yeah, so how negotiations work is the union receives a mandate from its members, and the Employers Association will receive a mandate from its members regarding any negotiation or any item of negotiation. If the parties negotiate and reach agreement, then that's implemented. If the parties negotiate but can't reach agreement, then the union would have the right to declare a strike, and employers would have a right to lock out if it gets that far. We are commencing with wage negotiations tomorrow in the Western Cape. We have our first meeting. So I can't comment on how that will turn out. But it's up to the parties to put the negotiations on hold. It's not up to an individual company to put the negotiations on hold. If negotiations proceed and if there is an increase of any kind and an employer can't afford it, that employer can apply for an exemption from those increases. But negotiations are either going to go ahead or by agreement with the parties, they won't go ahead. It's a government regulation that if somebody tests, you have to shut down for at least 2 days in order to sanitize. So under those circumstances, it is no work, no pay. It does fall under the COVID rules. And although COVID tours isn't being paid, the COVID rules still apply. So it's by government regulation that they have to shut down, and on the basis of that, it's no work, no pay. Okay, so the general principle in terms of an employment contract, an employment relationship is that an employer is compelled to provide an employee with payment if that employee presents themselves for work. If there's no work available, the employer is still required to pay that employee, except in the case, for example, of the furniture industry where we have a short-time provision in our collective agreement. So we have a legislative outlet to allow an employer to place an employee on short time when there's not enough work. But the general principle is an employee is entitled to payment if they present themselves for work. So using that principle, if the employer sends a worker home, the employer must pay the worker. If an employee chooses not to come in because of fear that they may contract the disease or fear for their safety, whatever reason, then it's unpaid. To put it bluntly, self-isolation is unpaid. If an employer sends an employee home, then it's paid, unless short-time provisions are applicable in the circumstances in which the employee is sent home. Okay, so I can only speak for the Western Cape, but the Western Cape Bargaining Council has agreed to give employers a holiday on the bonus portion of the leave and holiday bonus contributions for the short time hours only, not for the full week. And we've also offered employers a 3-month holiday on Provident Fund contributions. Those employers must indicate to the council which 3 months they would like to implement this holiday on the Provident Fund contributions for. It has to be 3 consecutive months. So that's what the council has offered, a holiday on the bonus portion of the leave and bonus calculations for short time only, and a 3-month holiday on the Provident Fund contributions. Those 3 months have to be 3 consecutive months, and employers must nominate the months to the council. All other contributions are payable. However, if an employer cannot afford to make these contributions, they may apply for an exemption directly in their specific case to the council, who will consider the application. Okay, so that's come up quite often over the past few weeks with employers needing to downsize and retrench, but simply not having the money to do so. The legislative requirements on employers will remain in place. If a company simply has no money to pay them, then there is no money to pay them, but the legal obligation and legislative requirements on them remain the same. If the company is a PTY or a CC and they retrench employees and are unable to pay severance packages, those employees have the right to refer a dispute to the Bargaining Council or to the CCMA and perhaps eventually to the Labour Court, where an order would be made to pay those employees the money that's due in terms of legislation. And where employers still can't, an attachment order could be made by the court to a sheriff to attach property belonging to the PTY or the CC. If you're a sole proprietor and you have assets, then those employees would have the right to attach your personal assets. So the money remains due and payable in terms of legislation. Whether an employer can honor that physically because there is money, because there is money or isn't, is another question. If there isn't and workers press the case, the employer's asset, the company's assets, the CC's assets could be up for grabs or attachment. My advice there is, if you can't pay it now, try and enter an arrangement to pay it off over time. There is no time limit. That will be part of the negotiation, or rather part of the consultation process. The parties need to try and reach agreement on when it will be paid, but there's no time limit. Many manufacturers here in the Western Cape, employers are faced with huge challenges. They've lost probably a third of their business since the start of the lockdown for this year. Some employers commenced with retrenchments as soon as they possibly could. Others have held out in hope that things would turn, and they embarked on short time for a period of time. And many of those are realizing that short time as an ongoing solution isn't pragmatic, and they've started retrenchment processes. A lot of companies have downsized, and we're facing challenging times. It's really difficult to advise an employer to rather work short time or to retrench. Each company is in a different set of circumstances, or facing different circumstances. Companies have different cash flow issues, but I reckon we're in for a long haul, and retrenchments will probably continue to happen over the next few months. And all I can say in that regard is follow due process, do it correctly, do it fairly, because if you don't, and you have a case of unfair dismissal against you, it's going to cost you more money, and money that you don't have at this stage, given the state of the economy. If you have any, also to any employers listening, if you have any particular questions or challenges, would like to know anything, you're welcome to phone me.
For our presentation today from Mr. Jerome Mausling. Thank you very much. And we hope to have you join us in our next session. Have a great day further. Thank you.
Thank you, everybody.